Yeah, ready to proceed.
Good afternoon and welcome to Licensing Subcommittee. Can I read some points from the protocol, please? Only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you're not speaking. When speaking, please be succinct. If you are having technical difficulties, please use the chat function in the Google Meet to alert the meeting. Please do not use the chat function for putting formal questions to the subcommittee. Any persistent disruptive behaviour will result in removal from the meeting. Thank you. Please could I ask the subcommittee to appoint a chair?
I propose Councillor Bell, please.
Seconded.
Thank you very much and welcome everyone to this licensing subcommittee hearing. We have no apologies for absence, do we? Everyone's here. Are there any declarations of interest by members?
None.
And we need to note that the second hearing on our agenda today has been postponed because the applicant has withdrawn their application. With that, if I move on to the application for Protein Studios. Our hearing procedure is set out on the page number 1, the printed agenda. I know a number of you have been to our hearings before, but if you haven't, the application is introduced by the licensing service. Then we hear from the applicant making the case for their application. Then we hear from any responsible authorities. And finally, we hear from any other persons objecting. At those stages, only the three of us, the three councillors, can ask questions. At step 6, we get into a discussion phase where it's possible to put suggestions, amendments between the parties, and we may be able to reach a conclusion that way. After we've discussed for long enough, I'll ask people to make closing remarks in the same order, and then you have to leave us and we'll make our decision, and we published within 48 hours to 5 days. Is that clear to everyone? You have all the persons, you have approximately 5 minutes combined to make your representations, but I'll be quite generous in the timings given the current circumstances. So sitting with me today are Councillors Emma Plouvier and Gilbert Smith. Can you wave or introduce yourselves? And I'm expecting to hear from applicants William Raw and Morten Jensen, and your solicitor Jack Spiegler, who was on the line earlier. Yes, are you back, Jack?
I'm back, Councillor. Yes, thank you.
Mr. Stewart from licensing, and I'm expecting Nicola Cavalieros.
Yes, that's me.
Yeah, welcome. Karen Rosen.
Yes, I'm here.
And Andrew Kantner.
Yes, I'm here.
Okay, so everyone's familiar with who's in the hearing. Can we kick off with introduction from licensing, please?
Thank you, Chair. Licensing Service received an application for a premises license under Section 17 of the Licensing Act for 31 New Inn Yard. After the report was published, the applicant amended the application by withdrawing off sales and late-night refreshment and have reduced their hours as stated in their supporting documents. And also one of the other person has provided additional documents, all of which have been circulated. Only licensing and other person representation remains. I have nothing else to add. Thank you, Chair.
Thank you. And you can just confirm that the updated hours and conditions have been circulated to all parties?
Yes, I can confirm that all the amended versions of the hours, conditions, proposed conditions has been circulated to all applicant RAs and other persons.
Thank you very much. Spiegler, it's over to you to make the application.
Thank you, Chair. Will from Protein and Morten from Oat are here to answer any questions about the premises, which is a Nordic-inspired coffee shop, restaurant and community hub with a plant-focused menu and a limited selection of premium alcohol proposed, such as natural wines and specialty oat brewed beer. There will also be showcase work from local artists on the walls, as well as local guest chefs. The launch of the business was interrupted by lockdown the applicant is now having to rapidly adapt to give the business the best possible chance of survival in extremely challenging circumstances. From the outset, I hope that you would agree that this 9 to 9:30 p.m. food-led and tightly conditioned proposal is not the type of license your cumulative impact policy seeks to restrict, and is in fact the type of application you would ordinarily grant by making a safe finding that the modest proposals would not add to cumulative impact. To hopefully clarify a misunderstanding, Will proactively consulted with Mr. Cantor pre-submission. He knew that Mr. Cantor was a local resident, and also by coincidence that Mr. Cantor was a previous tenant of Will's when he co-ran a coffee shop operating at the same premises between 2014 and 2018 himself. Will went away from that initial discussion believing that Mr. Cantor was content with a core hours restaurant license proposal that didn't overreach. It now appears that there was a misunderstanding, and the applicant apologises to Mr. Cantor if that is the case. There was absolutely no intention to submit an application that the applicant thought Mr. Cantor wasn't happy with. That indeed was the primary reason for consultation with him before submission, to ensure that he had no objection to the proposal. Recognising this and the other objections, the applicant voluntarily reduced the proposed hours, which are now 2 to 2.5 hours less than LP3 core hours. Off sales and late night refreshment were also withdrawn, and additional conditions were agreed in respect of the external area. The 9 p.m. proposal for the external seating area, which is also earlier than recommended in policy LP6, is critical for the applicant in order to provide the safest possible environment for customers with COVID-19 in mind. The applicant is confident that the reduced hours and comprehensive conditions address the other concerns raised in the representations, and by granting those the license, those conditions would be enforceable by law, giving local residents an extra layer of control that wouldn't otherwise exist if the premises operated without a premises license. The applicant would also like to clarify that the proposed license would not be used for the events cited in some of the representations. The limited hours, conditions and license demise simply wouldn't allow it. There is no representation from the planning authority, but you will note planning has been raised by the objectors. I ask you to note paragraph 14.64 of the section 182 guidance, which confirms that the planning and licensing regimes are separate and that you are not bound by planning. There is a planning condition restricting the hours to 7 p.m. simply because that is what the applicant proposed back in 2014. It was not a condition imposed as a result of objections. So insofar as it's necessary, under the new quite radical planning regime, the applicant is aware of the requirement to either comply or submit a Section 73 planning application. In any event, you must make a determination under the licensing regime, not planning, and I struggle to think of a single example of a premises license that has been restricted to 7 p.m. because it was deemed appropriate with the licensing objectives in mind. On policy, in paragraphs 9, 10 and 11, I set out submissions on the impact of COVID-19 and a number of reasons that I invite you to consider in determining that the premises will not add to cumulative impact in Shoreditch, and therefore the application can and should be granted under your policy. This is because this is a small, food-led, comprehensively conditioned 9 to 9:30 p.m. and policy-compliant licence proposal. We hope that your policy was not implemented to restrict this type of premises, which creates no realistic prospect of adding to cumulative impact in Shoreditch. The applicant's proposals instead will contribute positively to the daytime and early evening vibrancy of Shoreditch, and by granting the application, the applicant asks you to show support for a fledgling local business hoping to play its part in the responsible revival of the Shoreditch economy. Other than that, councillors, I just ask you to refer to the documents kindly distributed by your licensing authority. We've seen the correspondence between Will and the local residents more recently in my submissions, but otherwise that concludes our oral submissions. Thank you.
I don't dispute what you said about the planning and licensing regimes, but could we be clear? Is your client saying they're aware of the need to submit a variation on the planning application?
Yes, insofar as it's necessary. You may be aware, Chair, that there have been some wide-ranging changes to the planning regime, which has effectively replaced the former A1 and A3 use classes into a new E-use class. But insofar as it's necessary under the new planning legislation, absolutely, the applicant is aware of that. Okay,
and can we just confirm for the record, license is only referring to the ground floor premises, not any other unit within the studios?
That's correct. And if it assists, the reason the license application was made in the name of Protein Studios is because that's Will's company that was already incorporated. He's entering a joint venture partnership with Morton, who runs Oat, and in all likelihood, in fact, I think a new company, Oat Coffee Shop, has been incorporated, and the license may well be transferred to that company. The plan in the report shows very clearly the extent of the license demise, and that is restricted to the ground floor unit only, not the rest of the premises, which has historically been used for events, as mentioned in the representations, but is not part of the current proposal.
Okay, and finally from me, what's the actual capacity of the venue inside? We note you've agreed to the 35 limit outside. How many patrons can you get inside?
It's a bit of a moving beast at the moment because of COVID. So there's a risk assessment with I think a much lower capacity at the moment. But could I ask either Will or Morton to give an indication to the committee on internal capacity?
I'm looking for a figure pre-COVID, and it's the maximum you could fit in.
Morton or Will, could you help the committee with that one, please?
Yes. Hi guys. Sorry. We're looking at a head count internally of 35.
So 35 inside and another 35 outside.
Approximately, yes.
Okay, that's fine. Just want to get to councillors, colleagues. Do you have any questions at this stage? No? In that case, we'll move on to Mr. Chewett. Do you want to make your representation? David, to make your representation?
Yeah. Sorry, Chair. Thank you very much. The representation I made is at B2 within the printed agenda. So you see that the representation is on the grounds of the prevention of public nuisance, and I make reference to the premises being located within a special policy area, and that area is in place because of, and that policy is in place because of the some of the issues we have in that area with as a result of the cumulative impact of a large number of licensed premises in that area. I'm aware now, of course, that there has been changes to the application, which Mr. Spiegel has made reference to. So we've seen a reduction in the hours, the removal of the off cells, a tightening, if you like, of some of the conditions that are attached there. But ultimately, the premises is still within the Shoreditch special policy area, so that policy does still apply. So I'll just leave it there for now, Chair. Thank you.
Okay, thank you. Again, colleagues, any questions at this stage? No. In that case, do the other persons want to go in a particular order? If not, I've got Karen Rosendown first.
I can go first if that's okay, Chair. Thank you. I'm going to be very brief. I'm speaking because I'm a local resident in the area. I've been living in Shoreditch for 8 years, one street over from the venue. And what I've seen in those 8 years is I've seen the area go from bad to worse. And some have made the argument that post-lockdown, things are actually getting better. I'm here to tell you, as a person who watches this day to day, it's actually gotten worse. It hasn't gotten better at all. And I'm going to give you an example from Tuesday night. It's the most recent example I have. It's a pretty bad one. I was walking home on Shoreditch High Street by the Tesco, which is catty corner from where this venue is, with my daughter at 9 p.m. Tuesday night, weeknight. We were both offered cocaine and heroin by two men on Shoreditch High Street on a weeknight at 9 p.m. For me, that was a first. And that was about as bad as it gets. And I don't have to really say anything more about safety to children and public safety after having experienced that. I also just want to add that in terms of cumulative impact, this venue will add to it regardless of whether the hours are limited to 9 or 9:30 p.m. With more people on the street drinking, that leads to more problems we all know. Antisocial behavior, violence, noise, etc., need for more policing. It's really time for a reset in Shoreditch, not an increase in licensed venues. Since OAT, again, is in the special policy area, as we just heard, and there are no exceptional circumstances in their application, I believe it should be completely rejected. Thank you.
Thank you very much. Nicola, do you want to go next?
Sure, and apologies in the background for the toddler sounds. I have a short point to make, which is the council spent some money doing an amazing job on New Inn Yard, which has now gone from being a dirty, difficult to traverse space to a very pleasant outdoor space, cleaner. I'm a resident. I live around the corner. As I said, I have a 2-year-old son, which is what you can hear in the background. So we're in a situation where you've spent a lot of money and made things better, and now you're considering making them worse by granting a license that will see 35 people drinking on the streets. Personally, because of the SPA, it should be rejected out of hand. I appreciate that businesses are suffering, but I don't think that alcohol is a way to recover losses. That's just not acceptable as an option, particularly in a highly residential concentration, which is what we have around the venue. So, my key points are: I don't want to be walking down New Inn Yard with a 2-year-old having to navigate 35 people drinking on the street.
Thank you very much. Andrew?
Thank you. I just want to check, can you hear me? Can you make sure you can hear me?
I certainly can.
Thank you. So unfortunately, I have to start with the supplemental representations because the whole event really was misleading, somehow implying to the council that I agreed to revise hours, which obviously wasn't the case, but even more worrying was it was very clearly not the case after I had very clearly made clear that I didn't agree to them. But more importantly, having been involved in more of these hearings than I can count, I've never seen an applicant abuse a neighbor's name like that and send around to everybody really an objector's name, which really disturbed me. It was kind of a breach of privacy protocol and kind of common good sense, which actually shook me. But I've heard the apology, I accept the apology, but it was a very, very odd way of approaching it. But in any event, with that background, let me start at the end, which is say I firmly believe the application should be rejected. I want to talk about 3 topics: the application, the applicant, and the cumulative impact. My representations are at C3 in your bundle. First of all, on the application, obviously we need to remember that licensees come and go, but licensees are forever. And that's why we spend a long time trying to judge the licensee at the outset. I mean, just a couple of weeks ago, we were here discussing the Andina shadow license, proving that licenses are forever. So with that in mind, I have to say that the application is woefully deficient in any way demonstrating its suitability, let alone rebutting the presumption of the special policy area, in particular adding to the cumulative impact and upholding the license objectives. If you look at the application itself, it's bare bones. If you even include all the supplemental representations, it's still bare bones. I can't recall seeing anything like this before the committee in years. Even the Co-Balance Cafe up on Shoreditch High Street was significantly more detailed, and that was actually rejected in full. We really know almost nothing about the premises or the operations. Through supplemental submissions, we've been told the sum total of the information we know is that it's light drinks. We're now told premium drinks, natural wine, oat beer, Swedish and plant-based food. That's it. And these are nothing but soft assurances. Of course, nothing is legally binding for a premium drink versus a shot of vodka. And these are woefully deficient compared to other recent applications. Just consider, for example, nearby restaurants where the applications had assurances for the committee about the layout, the kitchen, the bar service area, the water stations, etc. We don't have any of that. The application has no proposed menu. There's no dispersal policy. There's no smoking policy. There's no fire assessment. There's no SIA policy to ensure safety. None of it. The application can't even commit to a seating plan. If you look at the plan on page B1, or sorry, the last page before B1, there's something about loose seating, which I don't actually even know what that is. There are no disabled toilets. There's no delineated bar area. There's no cold storage. There's no prep area. There's no extraction. There's no water station. There's no water storage, waste storage at all. There's also this issue about whether it really is a segregated space, but you need to be aware it's connected by a massive sliding door to a blank warehouse, some 4 times the size, and there are no conditions about how and when that door will be open or closed. We don't know anything about the plan other than some kind of weird marketing graphic that we were all sent that I don't actually really know what it means. But the one thing I know is it doesn't resemble a restaurant. What we do know is it's an application licensing the entirety of the pavement, which I've never seen before. This is not about the street. It's about the entirety of the pavement, with 35 people sitting on tables blocking wheelchair access and forcing blind people into the street. You can look at the photo on the second page of my representation at C3, and the red area is the pavement, is the licensed area, which I actually don't understand. So regarding the application, what I say is I struggle to find anything at all in the application that rebuts the presumptions for this area, other than really standard references to mostly mandatory policies like adherence to legally applicable waste collection. Quickly, much more quickly, just on the applicant itself, we don't actually really know who the applicant is. We've just been told that it may be Protein, it may be a company called Oat Limited. Oat Limited was set up in July 2019, so I don't actually know why they're not the applicant. But in any event, whoever the applicant is given some kind of soft assurances, but nothing legally binding. We do know that the applicant, who is Protein, has been using the space for years to host events in breach of the then applicable planning. The space was clearly limited to operations as a cafe until 7 p.m., but on the applicant's own website, they boast of literally hundreds of thousands of drinks being served over the years, nearly 1,000 drinks per event, just based on their own website. And yes, I'm deeply aware that planning has recently changed, and yeah, this space is probably now in the E class. But the point on planning is the long-term breach of planning is indicative of the nature of the applicant, and I think it has to be taken into account, as well as the hours, which I'll get onto in a second. In contrast, recent approvals in the area have pointed to applications and applicants with strong operating records. For example, the committee recently, in approving a nearby full-service restaurant, quote, took into consideration the applicant was a responsible and experienced operator and an experienced license holder of good character. But here we don't have any information at all other than these plain vanilla soft assurances about appropriate measures. And then finally, on the cumulative impact, I actually do want to point back to the planning to raise not the issue of whether it can be used for a restaurant, but rather the determination was very clear that there was a need to limit hours to ensure the local amenity. There's nothing in the planning statement that talks about the applicant volunteered to do this to ensure the local amenity. It says the decision was made to ensure the local amenity. And since that determination, there are many, many, many more residences in the area. Indeed, there are bedroom windows directly across the narrow alley. You can see that in the first photo in my representation at C3. The planning hours shouldn't be ignored, but quite amazingly, residents are never actually even raised by the applicant at all in the representation. The applicant doesn't live in the area. He may have in the past, I don't know, but he hasn't for many years. And what never gets talked about is what Karen just talked about, which is the actual conditions on the ground. And the stretch of Shoreditch High Street, which is really 10 meters away, is one of the busiest in all of London. I stood on that corner of Shoreditch High Street and New Inn Yard on Saturday at 8:30 p.m., some 10 meters away, and it was nearly biblically apocalyptic. So it's hordes of men and women staggering, drunken, passing in and out of Tesco for preloading. In fact, there were about 10 people standing right in the street, right in front of the proposed venue, drinking from cans and bottles. And the idea that tables would be set outside for 35 people here in the middle of these conditions is crazy.
Mr. Cantor, I have to ask you to draw your remarks to a close.
Okay, thank you. I would appreciate the indulgence. We're being asked to believe an academic argument that somehow things will be better post-lockdown. You've heard from Karen that it's not. It's getting worse. It starts earlier. You've read in the press about full-blown riots in the area, street parties, all within hundreds of meters. We're actually seeing it getting worse and worse, which is, being honest, a surprise. And none of this gets mentioned by the applicant. So in conclusion, for the above reasons and for the reasons in my representations at C3, I don't see in any way how this meets the standards to uphold the standards that the licensing committee works to uphold. And thank you for the indulgence on the time.
Thank you very much. I suggest we now move to step 6 so we can have a discussion involving everyone. Just immediately to address 2 of the things Mr. Cantor raised. There's no confusion to me. The applicant currently is Protein Mr. Rowe, no one else. And he can apply later to transfer that license to another party. At the moment, it's clear who the applicant is to me anyway. Second matter you raised is the area to be covered by the license. As far as I'm concerned, that's the area indicated on the map that accompanies the license and nothing else. It does not include an adjoining area within the premises at all. And we need to make that clear in the wording, and I will do so. But to me, it's not at all confused about what's covered by and what isn't. But I'll stop there. Perhaps Councillor Smith, anything you want to raise?
Yes, please. Thank you, Chair. There's a few issues, ultimately. I do believe that there is a smoking policy. Am I correct on that?
There are limits and a smoking area to be defined.
Yeah.
Yes, it was just no more than 5 persons at any one time outside.
Yeah.
Premises.
And I just want to talk about, security, dispersal policy, extraction, food, late night refreshment. This is to the applicant. If you could just sort of reassure us on those issues. And I have to say, I am also concerned about 35 outside as well, Chair. So I don't know if the applicant could maybe speak to those issues, please.
Thank you, Councillor. And I do appreciate Mr. Cantor's concerns about things being legally binding, but there is a legally binding condition on smoking, there is a legally binding condition on dispersal, and there are legally binding conditions in respect of the external area. The external area, which as I mentioned is absolutely critical with COVID-19 in mind, is a seated area for persons having a meal only, so no beer garden type activity, no standing, until 9 PM, which is 1 hour earlier than your recommendation in the policy. And there will be no music played outside. And if there are concerns, as I understand there are, listening to them this afternoon, and I'm sure the applicant will take those on board and make sure that the outside area is properly managed. While I'm thinking about it as well, Mr. Cantor raised another concern about shots of vodka. If you want something legally binding on that, then the applicant could agree a condition preventing the sale of shots or spirits in that manner. Premises too.
Chair, could I just come in?
Yeah.
So on the outside, you say people are going to be seated. I make that 7 tables with 5 people around each table. Would that be correct? How many tables are going to be out there?
Yeah, there's when we originally met the police, and at that time the police, I think, were happy with an outside capacity of 40, which was later reduced to 35, and agreed with environmental health as well. The plan actually shows how many benches there are, which, forgive me, I'll just have to find the page.
I believe it is 5.
Yeah, thank you.
So that's 5 times. So how many people can sit around each table?
Well, only 6 at the moment.
Okay, so that's 30.
Potentially 8. That's what subject to obviously the prevailing COVID regulations, it would be 6 at the moment, but potentially up to 8.
Thank you. And can you also talk about the fire risk a little bit as well, and fire exits, please?
So the plan is at page.
It's page 37.
Thank you, Chair, I'm obliged. So if you're looking at the plan, There is obviously the main entry and exit point. Bearing in mind it's a very limited capacity of 35, I'm not a fire expert myself, but I think at that level the numbers are low. But of course, the applicant is obliged under fire regulations to undertake an annual fire risk assessment, which would cover that off as well.
And Mr. Cantor, do you have sight of the plan? Do you have sight of the plan? Page 37 of the agenda. I think you need to unmute yourself, Andrew.
That can't be the first time that's happened.
No.
The fire risk isn't.
Do you have sight of the plan?
Yes.
Page 37. So the red area, clearly marked, is the only area to be licensed by this application.
No, I understand that. Can I just raise two questions?
Yes. Sure.
Which is, I understand it's the red area. However, the space directly connects to a large warehouse space, and there's no indication in the application at all how and whether and when that door would be fixed and closed, or whether it might be open at all times to allow people to kind of wander in and out. And the second question really relates to the outdoor space. What is being proposed? You know, as drawn, that's the pavement, which is utterly beyond me how the entirety of the pavement can be taken up with tables. What I suspect it is it's not the pavement, it's actually the street, given the way that the street has been redesigned. But that raises concerns as well of having tables being served alcohol literally right in the middle of the street.
On your first point, it's clear to me the only application we're considering today refers to the licensed area as marked on that map. Anything else we're not granting, we're not even considering. So I don't think that arises for us anyway. Pavement is an area to come back to. Councillor Smith, have you finished your questions?
Yes, thank you, Chair.
Councillor Plouvier?
No, I want to hear about the pavement a bit more. There was also raised about disabled toilets.
As far as I can see from the drawing, you have 3 sort of mixed-use toilets. There are no one particularly moved out for disabled persons. But is one of them adapted or whatever for such use? Who's best, Mr. Rowe?
Yeah, sorry, Jack. Yeah, I can clarify both those points. Afternoon, everyone. The first point on the pavement, it isn't actually on the pavement. When the street was redeveloped by Hackney Council, thank you very much, the design of the new street, shall we call it, was very much for pedestrian priority. I think that's, whether that's the actual term, but that's very much how it's been configured. So it is definitely not on the pavement. If anybody had seen, we previously had 2 black fold-down benches, which we're actually going to be removing because they were on the pavement for disabled or for blind access. That's our I guess sort of compromise. So they're actually going to be removed. So the actual benches are on, and it's hard to describe. Technically, I guess you would call it the road, but it's not a road. It's between the road and the pavement. There is a small curb which delineates the difference between the pavement and the road. But it's paved rather than tarmacked, so there's a clear distinction. What isn't actually on the plan that we can certainly add if needed is some additional street furniture, a couple of very nice trees, a couple of bike locking stations, which also I guess sort of contains the area because they're on either end. So there's no risk at any point that this is blocking any pavement or any walkways. And again, if that requires further clarification, or to be fair, the drawing is definitely could be better, I think, in terms of representing the exact configuration of what's on the street. To the second point of disabled loos, in the cafe currently, there isn't a disabled loo. But in the adjoining event space, there is a disabled loo, which has just gone in about 3 months ago. So if there is a need for a disabled access, it's on the ground floor, it's fully spec'd. That is possible, and that is also available. Thank you, Chair, Councillor.
Councillor Plouvier, if you may. Did I help you on that?
Yeah, I'm sorry. Just to go back. I mean, I'm now a lot more confused because you're licensing the area between your outside wall, the red line, and that has. I mean, is that not the pavement? I mean, are you suggesting that there's pavement between the tables in your building, or there's pavement the other side? I'm sorry, it just doesn't make sense.
Yeah, no, I am suggesting that. It might be easier to show a photograph, and maybe I'll need to check the photograph that was submitted, but that would certainly clarify. Outside the front of the building, there's a pavement. Next to the pavement is where the tables will be. So yes, there is, as I said, a clear delineation between what is pavement and what is not pavement, and also where the tables will be and where the tables won't be.
So they're the other side of the pavement from
Correct.
your premises. So your waiters will be walking out of the building, crossing a pavement of X dimension, which we don't know because it's not on the plan.
Yeah.
To another area, and I have to say that I don't quite understand how that works with. I mean, this plan is therefore very confusing, and as it's extending the licensed area out to this patch, the other side of the pavement, I'm not quite sure how that works, as though somebody will have to explain how that works.
I'm sorry to interrupt, Councillor, and you do raise a good point, and apologies for that. If you look at page 48 of the report pack, there is a photograph which I think will help to clarify. And looking at that, you can see actually that the plan doesn't show the full extent of the gap between the edge of the building and the start of the seating area.
So the distances are. I have looked at the photo. I think I did notice that there was seating that looked a set away from the premises. It's hard to tell from that what the relative distances are. So that I mean, that is what you expect from a plan. I'm sorry, but that is what the plan should have, especially as the plan is extending the licensed area outside the building. So it matters, and it matters that it's accurate. We can't currently accept that red line because it's completely inaccurate and doesn't give a legitimate representation of the situation. That's I don't know what, but because it's all to be on sales, it does actually slightly matter. And from that plan, I would say that from that photograph, it looks like the pavement is as wide as the area that has those black things that look a bit like sculptures but are actually tables. Is that right? So it's double the width. Is that correct? So it's 35 people who are set, I don't know, a meter and a half. I don't know.
I mean, Will might be able to confirm, but it's definitely more than a metre, but there's lots of clear space for pedestrians to pass by. I completely appreciate the plan needs substituting, but hopefully you can get a little bit more clarity from that.
So just to labour the point, but seeing as, because I presume that is somehow, I mean, how legitimately I don't know how you legitimately license a bit of the street that's as separate from your building as this is. Do you have some kind of permission? Right? I mean, what then limits that patch to one table rather than 2 tables wide?
There's no restriction in the Licensing Act as to what areas you can and can't license. So it's perfectly within the applicant's ability to apply for a license covering that area, obviously subject to you approving it and granting it. And that's the way we've managed it. I mean, the alternative would be to service the area by way of off-sale, but then off-sales were a concern of the objectors and the police.
Okay, well, the law may have changed, but I mean, normally we do on sales to the purlieu or whatever it's called under a building, so that on sale the red line would go to the bit that the building has permission automatically by being that building. There's an overhang or there's a mark on the pavement, or there are various views. Now that's not the case here. So therefore you're saying I've only decided to ask for a license to cover 5 tables worth, but I could have asked for a license to cover 30 tables worth in this square. Is that the situation legally now? Because
So what we've sought to do, and I do appreciate that you've got concerns about it, but what we were trying to do was, by including that area on the plan, everybody can see very clearly, and particularly enforcement officers on the ground, what area is licensed for licensable activity.
I absolutely understand that. That's not what I'm asking. It's not very clear because the plan is misleading. But what I'm asking you is, what gives you the legitimate claim to that piece of land? And, you know, you're saying you could have claimed the whole square. Is that the situation? I mean, I don't know, because it's only, after all, the London Borough of Hackney that put this together. Maybe they've given permission with this building for you to have the whole square and fill it full of tables and sell booze. I don't know, but that's what I'm asking. Is there something magical about that strip that enables you to ask for a license for it? Because normally you can't ask for a license unless you rent or own that property.
Can I ask Will to clarify? Because I think Will, some of the persons involved in the pedestrianisation of that street encouraged the use of that area. Obviously, Councillor, we're asking for permission for it now, and I do appreciate you've got concerns. We're not claiming we have a right.
We might not be able to give that permission because that permission might be in some other department, is what I'm querying here.
Yeah, and hopefully to clarify your point, Councillor, when the street was completed and the previous operator was operating, a company called Visions, and I forget his name, and I can certainly provide it at another time, was actively encouraged us, or Visions, to activate the street, I think was his words. And so the black benches that are currently there, actually similar ones to them, were bought and put outside. If it would help, we can certainly obtain, written confirmation of that permission. But it was very much, from our perspective, I guess, or authority or certainly acceptance of us, Visions, the operator, using that stretch outside of the cafe to facilitate their operation and their day-to-day business. So that's certainly something we can confirm in writing, but the understanding so far was verbal with our local council representative when that work was signed off, and the previous operator was using it.
And of course we can contact the markets team for clarification on that point.
Yeah, I think it was actually the markets team. You're right, Jack.
My understanding, prior to any recent changes to legislation, would have been that they needed a tables and chairs license from our highways department. Amanda, is that correct?
Yes, that's correct. Yes, I was actually going to ask whether or not they'd got a tables and chairs license as well. But when they are they the actual owner of the premises, or are they leasing it from Visions, or what's the?
Sorry, Councillor, can you clarify that?
Do you want to clarify the nature of your interest in the premises? Are you leaseholder, freeholder, or what?
We are a leaseholder. The freeholder is Jeremy Fulkus, who is the building directly behind us.
Does that help, Amanda?
I think, yeah, I can see that, they've just been going on what they've been told, but I think they do need to check that they have the right permissions in place to use that area, because it will become a problem later on. So I would suggest that if they're not clear on it now, to check the lease very carefully as to the extent on which they're permitted to use.
And to the extent that it's required, of course, the applicant can apply to the Markets or Highways team for a pavement licence or tables and chairs licence.
Councillor Plouvier, do you have any other questions or points? Okay, Mr. Tuitt, have you heard anything that you want to comment on?
I guess it's just still about the same point about the tables and chairs outside. Is the applicant saying that they don't currently have a pavement license for that space? Because my expectation, just looking at it, is that it is public highway.
The applicant does not currently hold a pavement license or tables and chairs license. I think the confusion has arisen because it is a slightly unusual street following the works, and Mr. Rowe received some guidance, albeit oral, from a member of the Markets team that he was good to put seating outside, because historically there have been.
Okay, Mr. Cantner.
Sorry, just sticking to the pavement for a second. So the photo you're all looking at is my photo. One thing that you'll see from the photo is that there are 2 tables there. And the applicant is proposing 5 tables, which runs virtually the entirety of that street, almost all the way up to the next premises, which, given the current problems we're having, what that looked like at 8:30 p.m. on a Saturday night is, in my view, incredibly aggressive and damaging. I don't come to you lightly with this heavy heart. I think I've earned a reputation as an honest trader in what we've seen in the neighborhood. Just one final small point on the disabled toilets. In order to access the disabled toilets, this large sliding wall into the adjacent event space would need to be open at all times. On your floor plan, sorry, I don't have the floor plan in front of me, but that's the point about the large sliding wall, which is the license area clearly is the red outlined area. But in order to access the disabled toilets, that large sliding wall will always need to be open, effectively resulting in one very large space. And I'm not sure how that can actually be accomplished within the proposed restriction.
That's not an issue for us. The provision of the disabled toilets a legal requirement, and we're clear that the licensed area does not extend to anything else.
No, I understand. However, to maintain that integrity of just the licensed area, normally you have walls around it, and in this case, it won't.
Nicola.
Yeah, I just wanted to add one consideration is the traffic in the area. So because of the one-ways, because of parking and building and things like that, we actually have quite a lot of taxi traffic going down Union Yard, coming around Bateman's, to come around to Bateman's Road, and that's even heavier in the evening as people are being dropped off for the bars and things like that. So that's a real consideration when we're talking about a stretch of road or pavement or whatever it's going to be. There's going to be full of people who are outside who are drinking. So difficult to walk. If you're walking on the pavement, there are waiters coming. From a COVID perspective, there's congestion. Then you can't step into the street safely because there's a fair amount of traffic that you have to be conscious of. So, I mean, obviously we can all walk the streets in a conscious and responsible way, but we're talking about turning an environment that at the moment is quite easy to navigate into one that's quite congested during the busiest times of the week in what is already a busy area.
Okay. I mean, I can see benefits from having chairs outside, adding to the traffic calming effect in the street. I was quite encouraged by the photographs Mr. Cantner sent in of how the street now looks and how it's been traffic calmed.
I'm talking about filling it with people and traffic, because we do have traffic that comes around. I mean, we're on a block. We're on the west side on Ewan Street. And basically there's a huge amount of traffic that goes around that square block, either coming from Shoreditch High Street or from Curtin Road, to go in both directions. So just saying that there is traffic on that street. Now we're talking about putting pedestrians and drinkers into the street. So the changes have been for the positive, but I'm arguing that putting more drinkers onto the street doesn't really help the situation.
I'm quite surprised that the hours they're proposing don't give you some comfort on that.
But with all due respect, Councillor, the drinking in Shoreditch starts at around 4 or 5 o'clock, particularly on a Friday and a Saturday. So 9 o'clock makes no difference because a lot of people are drunk by 8 if they've been drinking from 4. If you're in, even people coming up from Liverpool Street Station have got a beer or something in their hands. It's not that people turn up and are about to go out at 6 or 7 o'clock. And this is the whole point about cumulative impact. It's not because you restrict hours that people don't stand outside and drink. I mean, we sleep with our windows shut, 365 days a year because of the noise on the street. And that's fine. We've learned how to do that. We love the area and we're happy to be here. And, that's one of the costs of being here. But let's not pretend that that's not what happens, because it does happen. So there are frequently people standing outside our bedroom window, and you move outside and you say, please will you move on, we're actually sleeping here, and people aren't aware that it's a residential area, and they're kind of spooked out of their minds when they hear a voice from above saying, we live here, can you move on? So this is not about it only happens at 11 o'clock or it happens at 3 a.m. It starts at 4 o'clock as people are coming in for the night. It doesn't make any difference to me whether they close at 9 or close at 11, frankly, because people are already drunk by then. Karen's talking about, being offered heroin and cocaine at 9 p.m.
Yeah. We do need to focus down on this application and what it could cause.
Well, it's cumulative.
If we were to consider refusing it.
Mm-hmm.
Councillor Smith.
Yeah, Chair, I was just wondering how we kind of resolve the issue of the fact that they don't have a table and chairs license for that piece of outdoor space there. I'm concerned that it's going to be very difficult for us to make a decision.
Could I be so bold as to make a suggestion on that, because it's clear you have concerns, and as is the case with these hearings, I've been chatting away with Will and Morton on WhatsApp. In my view, it'd be perfectly possible and lawful for you to grant the application with an additional condition as follows: there shall be no supply of alcohol to customers outside the premises until such time that an accurate plan is lodged with the licensing authority and an appropriate consent is required from the local authority insofar as one is required. So that would mean the applicant could not sell alcohol outside until the plan issue was corrected and until a consent is in place insofar as one is required, whether that's a pavement license under the Business and Planning Act or a table and chairs license under the former regime.
Amanda, do you think that would be acceptable?
Yes, I think that's acceptable, because at least then that restricts the use of the license until they have that in place.
Councillor Smith, does that help you at all?
Yeah, it's eased things a little bit. Yes, thank you.
Councillor Pluvier, anything else you wanted to?
Slight breach of protocol.
Just a moment, I'll just let Councillor Pluvier conclude. No, you okay? Spiegler?
Thank you. Just while we're in discussion phase, just for the applicant's benefit, may I ask through the committee a point of clarification? Would it be possible to confirm whether all of the residential objectors are from different households or similar? Because we don't.
No, Mr. Speaker, I'm going to rule that question out of order.
Okay.
They're entitled to object, and I don't see any problem whether they come from different households or not.
I apologise.
You did offer an condition on shots. I'm not personally overly concerned about that. I mean, if they're serving expensive beers and wines, I'm not overly concerned. But are colleagues interested in taking the condition on shots?
I think it was a concern of Mr. Cantor. I understand he would like as much as legally enforceable as possible. If you're minded to grant with the conditions, then the applicant would not object to a condition restricting the sale of shots or spirits, and I'm happy with Ms. Newth's wording on that however she prefers.
Well, sorry.
Yeah, Ms. Gardner, go ahead.
I used it as an anecdote, as an example, really only to highlight that the descriptions that we've been given, which are the barest bones I've seen in an application in a long time, are nothing more than soft assurances. And even more importantly, won't apply to whoever the next licensee is, because licenses last forever. So, I mean, I suppose if we're going down this route, which I really don't think we should, it's the license would be restricted to what we heard, which is oat beers, premium cocktails, and natural wines. But that isn't the way the license committee operates, or licensing normally operates. It's just to generally highlight that in the context, in particular outside, that there's nothing like this in the area at all. There is no 35 outdoor seating in the middle of a road, effectively on the corner of the most busiest part of Shoreditch. And that, as you've heard from the others in particular, it's a tough area. This adds a natural impact, and in particular the outside, we think it's a very bad idea.
Mr. Gardner, we do regularly set conditions on the types of alcohol can be sold. It's not at all unusual for us to do that.
Okay, all right. Well, I definitely not in a position here to, or wouldn't ask anybody, including the applicant or obviously the committee, to dig through this, because we don't actually really know. In terms of in writing, all that we've heard is it's a Swedish plant-based cafe. That's it.
Councillor Bouvier.
Can I? It was raised by one of the objectors about I understand that Protein is one company that's maybe already been there, and Oat is another, which may reflect by its name, give us some idea of what it's selling. But has Protein been a business that previously sold alcohol in these premises on any scale? Because we don't have a context of how the premises have been used before.
Mr. Rowe?
Sure, thanks, Councillor. Answer is no. We haven't sold alcohol at scale. There have been an occasional applications for attends, which are related to a couple of events that we have had in our event space, and also our annual or biannual street party, which is a fundraiser for Amnesty International, our neighbour just the other side of the bridge, which we applied a 10 for to sell alcohol with the funds or the profits from going to Amnesty. So yeah, we have done on occasion, and I think if you dig into the TENS history, you will see how many that has been, which is limited also in our lease to 10 a year, and we very rarely use all 10. So in the context of this, it is not something we've done before.
So that's so just so I understand it. So the tenses that we have details of in the pack, those refer to the whole premises, not just the premises we'd be licensing.
Correct.
They were used in something much bigger and were bigger events. Yeah.
Yes. Separate.
Separate events. So that may be a Protein thing that if we were out of COVID, that's something else. It's a different business.
I mean, it is what we run the building as, upstairs as a workspace for local creative businesses, and downstairs for a pop-up retail space and for events. But as I've included in my submission, we are currently reviewing that in its entirety, due to the fact that events legally can't take place, and there is no clarity for the foreseeable future as to when they will return. So we are effectively reconfiguring exactly what will be downstairs. We are currently talking to a number of tenants about long leases. Firstly, we have a shop front at the other end of the building next to Frame, for which works as a pop-up retail space, which we'll look into actually lend as a rent as a retail, but for the main event space to actually turn into a commercial office space.
Okay, so just to, because I don't think we need to know all of that, just to
Sure.
confirm, you said that you were limited to 10 events under your lease.
Correct.
So this is because it was one of the residents who raised this issue of it being so an event space, and I'm just
No, it wasn't actually.
for the committee, and because it was raised by the applicant, and what you say may or may not reassure the applicant, and they can refer to it if they want to.
Yeah, apologies for interrupting, Councillor. No, it was actually raised, my memory serves me right, by the agent who was consulting our landlord. So there was no objections to it prior. It was a clause put into our lease with our landlord.
Okay.
Can I clarify just quickly, because I think it will help, and I don't think Will disagree. The licensed area that's under proposal has operated as a cafe for about the last 5 or 6 years. Closed all during normal hours. There have been events after hours, obviously in that space as well as in the adjacent warehouse space. I guess the one comment I would make about the 10s is it's not just a few events. The Protein website itself talks about nearly 600,000 drinks over the last couple of years. So it's probably not relevant, but it is on their own website.
Okay, but no one's suggesting this restaurant would sell anything more than a limited range. Is that correct?
Correct.
Oh God, I hope not.
Councillor Smith, anything further?
I mean, I don't want to labour the point about the number of tables on the street, but I think it's important to maybe just ask the question: would the applicant consider reducing the number of tables? I think I'd just like to know that.
Is that a general concern, Councillor, or specifically in relation to the alcohol consumption outside?
Yeah, just to the alcohol consumption outside.
So the police and environmental enforcement authority were content with 35. I think that's the theoretical maximum. It doesn't necessarily mean there would be 35 people out there drinking all at once. It would.
That would mean surely 7 people to a table.
Yeah, exactly.
And even in normal circumstances, that's quite packed. Yeah. And currently, you couldn't have that for distancing.
Exactly. I mean, I think if it assures you, the way I phrase the condition is that there can be no alcohol outside until such consent is in place. So that would have to go through the scrutiny of the Markets Authority on that point. And then if there are complaints or issues, then of course there's a renewal requirement for that, so it could be picked up at that stage.
Chair, can I just chip in?
Yes, certainly. Yeah.
I'm just looking at Google Maps, and I don't know obviously when this is from, but I'm looking at the street on Google Maps. Sorry if I'm not allowed to do that, Chair, because it's not in the pack. But just for my reference, is it okay to continue?
Yeah, I think it's publicly available information. I don't think.
Okay. On Google Maps, I can see some white tables. I don't know if they were there before, but there's only I think about 3 along there. So I'm agreeing with Mr. Cantor that 5 seems a bit too much to me.
That sounds similar to Mr. Cantor's photographs when he sent us in terms of the number of tables.
Jack, do you want to come back on that?
Yeah, I know I might need Morton and Will to come back, but because of the pandemic, everybody is seeking to maximise external seating, particularly at the moment. It might be that the 5 tables is a short-term thing. It might be longer-term, depending on how it goes. But Will or Morton, could I hand over to you on that point?
Sure, thanks, Jack. And Councillor Smith, to answer your question on the Google Map reference, that was actually for an event. It was the Pulsar car launch. So those white tables were a temporary of temporary use, shall we say, for that afternoon that car launch was happening. But I think from an additional hopeful clarification, the events do not stretch the entire length of the building. For just again for additional clarification, they stretch to maybe a third of the building outside where the cafe is. And if it would help, we can certainly revise or limit the number and size of tables, which in turn will also limit the number of people. So I think that's something that we'll sort of happily look at to provide that additional reassurances of the outside space. But just wanted to add to Jack's point, and certainly in the current sort of situation with COVID and the opportunity to have outside space is vital for a successful cafe to operate. And that to us was a key consideration, as inherited from the previous operators' visions, who had very successfully their tables outside, but equally understanding that we will revise the licensing addition to the outdoor seating once we've also confirmed the tables and chairs license with the relevant department at Hackney Council.
Mr. Rowe, if you want the application to go ahead today, we would need some clarification fairly immediately on that.
Correct. Understood.
Are you asking for it to be adjourned?
I refer to Jack on that.
No, we're certainly not asking for the application to be adjourned. We are asking you to grant the application subject to that condition, which would leave the markets team, I believe it is the markets team, who are perhaps the most qualified to decide on how much seating is appropriate outside, to determine what they are prepared to grant, if anything at all. If an application is made for 5 benches and they deem that too much, then the applicant will not be able to place 5 benches outside. If they apply for, or determine 3 is appropriate, then 3 will be outside, and then the condition allows the applicant to supply alcohol to persons on 3 benches outside. And then
you're asking us to agree a license that has up to 35 people outside on 5 tables, 7 people at a table. That currently just does not work.
It's subject to that condition, though. So if the consent was issued by the markets team for 3 tables, then that would supersede the condition for 35.
But it is in danger of making the condition on the license meaningless.
Well, we could work with, so we could amend that condition to say that not only shall alcohol not be supplied to customers outside until such time as a consent by the markets team is granted, but that any external seating shall only be placed outside in accordance with any consent granted by the markets team.
That wouldn't satisfy me. Anyway, Councillor Bouvier.
Oh, sorry. Thank you, Chair. I just don't think it's complete. I don't think it's mentioned anywhere. I have looked. Sorry if it is. Are these permanent tables, or do they get taken away when the cafe closes?
Sorry, Jack. Thank you, Councillor. Yeah, these are bench tables that get folded down and taken inside at the close of business.
Is that clarification enough? Mr. Speaker, Mr. Rowe, what I'd be looking for if I was to support this would be the external capacity figure to be reduced and not rely upon the secondary process of tables and chairs licensing, but the condition within license to have a reduced outside capacity.
Thank you, Chair. I'll take instructions now, but obviously we'd originally asked for 40. The police and environmental enforcement weren't happy with 40. They were happy with 35, which is what we've proposed to you today. If that's too much for you, then it's completely within your power to come up with a lower limit. We just ask, particularly bearing in mind the struggles of COVID, that you maximise that as much as possible.
I'm actually trying to be sympathetic, but clearly 7 people on a table does not work even in normal times. You're not going to fit 7 people on a table.
I don't think you're with us on that point, Chair, so I won't push it any further. Until 9 PM, we'd say, which is well within the policy hours, LP6, we say it can be managed without compromising the licensing objectives. The applicant would be willing to agree a limit of 30 if that assists you. If that's not enough, then of course it's within your power to determine what you think is appropriate.
Instead of contact each other on WhatsApp, would it be useful to us to adjourn the meeting for 5 minutes and allow you, the applicants, to discuss further?
I appreciate the offer, but I think 30 is, we've clarified 30, Chair. Thank you.
Okay, Mr. Tuitt, do you have anything else you've heard you want to raise?
Maybe just to hear that condition again that's been suggested by Mr. Spiegler.
So that's the one about until an accepted plan and consents are issued.
Yeah, that one, because from what I'm gathering, if you are minded to grant the condition in relation to spirits, is not something that's going to be explored. So yeah, just that condition in relation to tables and chairs.
Can you read back that text, Mr. Spiegler?
Thank you. So it's actually just my notes. There shall be no supply of alcohol outside the premises until such time that an accurate plan is lodged with the licensing authority, comma, appropriate consent to place furniture outside is obtained by the local by the applicant, and any furniture placed outside shall be in accordance with any consent issued by the local authority. The extra bit on the end would safeguard, I think, your concerns about lots of additional furniture being placed outside and controlling capacity.
Okay, I would read, from me, it would read until such time an accurate plan is lodged and accepted by a licensing authority.
That's agreed.
Councillor Smith?
Yeah, sorry to labour this point still, Chair, and I know that you've decided on 30.
We're here to be Labour, Vincent. Gilbert, sorry.
But just going back to the Google Maps picture that I've got here, and Will, maybe you'll be able to help me here. I mean, I'm just looking at it, and there's some people sitting in the street here. Sorry?
Nicola, I've seen you put your hand down. Sorry.
On each table, I can see 4 people sitting at them, essentially, roughly. And there's 3 sets of tables there. So 3 times 4 is 12. You know, I'm asking you one more time to maybe reconsider the number, I suppose.
I'll put it a different way. Would a limit of 20 maximum damage your business fatally? Mr. Rowe.
Thank you, Chair. Could I just confer with my partners on that point?
Okay, I'll give you a couple minutes.
Thank you.
If I could add in the silence, just I'm drawing a parallel to.
Sorry, can I ask you to stop?
Yeah, sure.
I want to have a short break where we can talk to each other.
Okay.
And come back when we have the same information.
Okay.
Thank you for this, appreciated, Will.
Yeah, sorry, Chair, I'm going to hand that one to Jack.
The applicant, and again, I fully appreciate we're pleading COVID-19, but it's an unfortunate reality. Would be grateful if you would be so kind to agree 25, bearing in mind that is an absolute limit and not one, particularly as the winter months approach, would be reached on very many occasions.
Okay, that's helpful at least. Nicola, you want to make some points?
Yeah, I wanted to go back to the size of the tables. I'm thinking of Padella, which is round the corner on Epworth Street, and most of their tables seat two to a maximum of 4 people. So I think part of my concern is bigger tables with, you know, groups of people. Whereas if this is a cafe and people are drinking while they're taking a meal, then I think Patella is a good example of smaller tables that are further apart. They're turning their tables quite often. And, you know, that might be a better model to look to than larger bench tables.
I think from our point of view, we'll want to set that overall capacity. I'm not sure we're going to drill down into prescribing the format of the table, I'm afraid. I do take the point, but I think we're going to have to accept we're going to make some kind of benches that can also not only be put out and taken in easily. Councillors, any further questions or any points? Gilbert?
Sorry, I just need to unmute myself.
Yeah.
Yeah, just, I mean, basically, again, looking at the picture, I know I'm sort of labouring this point, but I think it's really critical for all the objectors in terms of the tables. I can see 3 there on the Google Maps. Now, you know, if you had 3 tables as set out for that event, Will, and you had 6 people on each table, that would be 18. So 25 is obviously 7 more than 18. You know, is there, I mean, how much room is there down there for more than 3 tables, I suppose is my question, Chair.
Thank you, Councillor. Yeah, there's, again, just to reiterate, the image from the Google Street View is from an event. So the tables, the white tables that you see there aren't the actual tables that we'll be using. The tables that we're using are the ones that Andrew Cantor, Mr. Cantor, submitted outside our building, which are flat pack, black bench tables. In terms of space, there is space to have you know, more than 3. We've never had, I think we only have 4 tables currently in terms of the black bench tables. But I think really for I guess a reassurance, I think to both yours and to Nicolette's point, it isn't necessarily to us about the number of tables, it's about the number of people who are at the tables that is really, I think, for us to clarify and agree on. Because often there is, you know, 2 people at the table, but sometimes there might be 4 or 6. And I think the configuration of and the style of those tables, that actually gets quite cozy, shall we say, and this is regardless of COVID restrictions to have more than 6 on each of those tables. But as Jack has offered in terms of a revised suggestion for the outdoor seating, I think there shouldn't be any concern that 25 is A, manageable, and B, would not take up you know, an extensive part of the east side of Newham Yard. But again, we can provide, and as Jack has offered, additional clarification of the exact plans, and if needed, photography to reassure the exact location, style, design, you know, with people, without people, whichever is required.
And just to add to that, if it assists you in terms of the management of the external seating area, the model condition offered in respect to the dispersal policy being in a form agreed with the police and licensing authority, perhaps that could be amended to say that there should also be an external seating area management plan and dispersal policy in a form agreed with the police and licensing authority.
External area seating management plan.
And it would just be a simple addition of those words to condition 7 using the numbering in my supplemental agenda pack.
Okay, Amanda, do you think there are any matters we haven't asked about we should? You're muted for a second. You're muted.
No, I think you covered everything. Thank you.
colleagues, do you have anything else?
Sorry, can I just mention it, although I know it's been touched on, is just that the council, for members to think back if they're satisfied about the points made on the cumulative impact, that's all.
Yeah, Mr. Speaker obviously made some points in his pack about the reasons why he believes we shouldn't be an exception to cumulative impact rules.
And just to clarify, a point raised by one of the interested parties is that the applicant hadn't offered any exceptional circumstances. In your policy, particularly paragraph 3.6, there isn't a requirement necessarily to present exceptional circumstances, but instead to demonstrate to you that the proposals will not add to cumulative impact. And we say that the reduced hours, the conditions, in particular the condition requiring alcohol only to be sold to persons taking a table meal, and all the other concessions made by the applicant since receiving those representations mean that this is not the type of premises that you associate with cumulative impact in your policy. It's not late night, it's not big, it's not entertainment led, it's not alcohol led. And for those reasons, we say that the applicant can successfully demonstrate the proposals will not add to cumulative impact in Shoreditch.
Okay, I'm going to sometimes move to summing up speeches. So if any other persons disagree with that statement, get ready to argue the case. But first of all, if I could just ask colleagues, is there anything further either of you want to raise? Gilbert? Emma in particular, normally we'd have the option of adjourning to have short discussions and then coming back into the hearing. We can't do that at the moment. The issue about how we delineate the area to be used under this license, is it such that you feel you couldn't reach a decision today?
You're asking?
Yeah, is it such that you feel you could not reach a decision today?
Could not reach a decision?
Yeah.
I was hoping to hear the licensing officer again on that, but I understand the condition. We would have to decide based on the condition that's been offered at the moment. I'm not saying here whether I think that's adequate or not. I mean, I don't think there's any alternative, given that we were presented with all this as is, which wasn't satisfactory. But the condition certainly gives us an exit route, which is fair enough.
Okay, I raised that because normally we might adjourn and privately discuss that and then return, tell the applicants we need more information, but we can't do that in the current arrangements. So
I don't think we need more information, do we? I mean, we haven't been given enough information, and therefore the lawyers come up with a condition to try and cover those eventualities. People may or may not have, I mean, I don't want to, I don't think there's anything to add. Is basically the situation.
Yes. Okay. Great. That's what I want to get down to. So I've said I take closing remarks in the same order as initial remarks. Mr. Spiegler and Mr. Rowe.
Thank you, Chair. I'm conscious you've heard a lot from me this afternoon. I'm very grateful for you helping me clarify those points. So I'm not going to offer anything else in closing. Thank you.
Mr. Rowe?
Nothing more from me either. Thank you very much for your time, everyone.
Mr. Chewett?
Nothing further from me, Chair. Thank you.
Okay. Ms. Rosen?
Yes, please, on cumulative impact. I just think it's false to say that this is not going to add to a cumulative impact in the area, even with 25 people outside, it will still add. And there seems to be this idea that somehow because it's natural wine and premium beer that people will get less drunk, maybe? I mean, that's just rubbish, so I'll leave it at that.
Ms. Cavalieros?
Yeah, I'm just going to add on cumulative impact. I think every time you open the doors and people are drinking outside, you have cumulative impact. That's the nature of what happens in Shoreditch. I've been here for 10 years. I've never seen anything different.
Thank you. Mr. Kantner, you have the last word.
All right, I'll keep it short. Just addressing this point of exceptional circumstances. Ironically, it's the applicant that's trying to plead exceptional circumstances of COVID. And I think you've heard from 3 people, all parents who have all lived in the area for about 10 years, all of whom have children and all of whom live within 10 meters, who have told you that things are really getting worse, much to our surprise. And ironically, they were actually getting better. But post-COVID, they're getting worse. And to the extent there are any circumstances to be taken into account, I hope you can understand that. And that in particular, the outside area, is the thing that tremendously bothers us at all times of day.
Thank you very much.
Thank you.
As I said early on, we will try to reach a decision and publish it as soon as possible. It will first appear on the part of our website, calendar meetings, but it will also be sent directly to the applicant, anyone else on request. So if you don't hear within 5 days, absolute maximum, or can't see it on the website within 5 days, get back in touch with our committee officer and we'll try and clarify where we are on it, but I'm sure we'll have published it before then. Thank you all for attending.
Thank you very much.
Thank you.
Thank you all.
Thank you.